Hi, everybody. Thanks for your time and for attending this First Friday event. Today, we've got Alicia, who will be talking about how to protect and manage intellectual property. And hopefully, at the end of the session, we'll have um, a few questions from the floor, and at the end, we can then hopefully just talk a little bit about the next session we're doing, which is going to be next month, and that's going to be a really interesting one as well, because we've got Pippa from the BFA talking about the 2024 industry report which came out, which is really interesting. But for now, we've got Alicia, and the floor is yours, Alicia.
Thanks for the introduction. Hi, everyone. I'm Alicia West. I'm a senior associate at IBB Law in franchising team, but I also specialise in intellectual property. I'm going to be talking about protecting intellectual property in a changing world. And I've got some slides, and bear me one second while I just share my screen. So hopefully this will work, because I have two screens and it gets rather confusing. So let's just double click that. I'm hoping you're seeing a picture of a lady. Yeah. Perfect. Thanks. Because last gets a bit confusing with two screens, so bear with me. So, trademarks. So, branding is an important asset to a business, and it can help it grow. A business has invested considerable time, effort, and money into its brand, and will want to ensure that no one else can copy it. Any unfortunate association with a name can scar a company's reputation, even if the connection is coincidental. So, what is a trademark? A trademark is a badge of origin used to distinguish the goods and services offered by one trader from those offered by another. And I put some examples on the screen here. A trademark can be potentially anything represented graphically. So it can be words. So M&S has the words Colin the Caterpillar trademarked. It can be a logo, so such as the Adidas symbol. It can be a slogan, such as Nike's Just Do It. It can be a pattern, such as the Louis Vuitton print. And it can also be shapes. So Coca-Cola has a shape mark for their cola bottles. So once a trademark is registered, it gets its protection through the Trademarks Act of 1994. And on registration, the owner has the statutory right to the exclusive use of that mark in relation to the goods and services that it's been registered for. If a brand doesn't have a registered trademark, then a brand owner will have to rely on the common law right of passing off, which is a bit harder to prove. So registering a trademark and protecting it. A trademark may be infringed if another business uses the same or similar mark in the course of trade in relation to the goods and services identical or similar for what the trademark is registered for. So to be registered, a trademark must meet the requirements of registration. And this includes being distinctive, so capable of being distinguished from other brands. It must be graphically represented, like I showed on the previous slide. It can't be descriptive of the goods and services to which the mark is being applied for. So you can't call your new ice cream brand Alicia's Amazing Ice Creams, because it's basically saying I'm selling ice creams that are amazing. And it can't also be similar to an earlier registered mark. As a brand's reputation grows and becomes more established, it's more likely that third parties will start to copy it. And having the protection from a registered trademark will mean that the brand owner can take action to stop this. And I put a recent news story on this slide involving a company called Brixton Streetwear, which are a community clothing brand based in Brixton, South London. And Brixton Streetwear are involved in an ongoing claim against a company called Brixton LLC, which is a US-based clothing company. And Brixton LLC sent them a cease and desist letter demanding them to stop using their name because they've got a UK registered trademark applied to goods, namely clothing. And this case raises the key issues of the enforcement of trademark law and whether Brixton LLC can enforce its trademark rights over Brixton Streetwear. Brixton LLC has 3 trademark registrations specifically in relation to clothing. And the Trademark Act 1994 allows traders to register distinctive signs used in the course of trade which can include geographical names if the place in question has no association with the goods and services. The word Brixton isn't strongly associated with the making or selling of clothing, but if it was, then it's likely that Brixton LLC's trademark would be declared invalid if it tried to enforce it. This case is going on. There was a decision last year in the Intellectual Property Office, and I understand from reading around that they're probably entering into negotiations. But the case study highlights, amongst others in recent news, you'll see quite often EasyJet, Easy Group enforcing their trademark rights, about the careful balance between brands enforcing their trademark rights against third parties, against the loss of goodwill it may get from a negative PR impact. So the costs and timings of a UK trademark registration. There are two ways of applying for a UK trademark. There is the standard method, which is an all-in-one method. So if the IPO don't like it, you've got to start again. Or there's a right start method, which is about £30 more expensive. And the IPO examiner allows the applicant to make very slight changes to allow it to meet the rules of registration. Once a trademark application is submitted, the IPO have a look at it. And if there is a prior registration, which they think is similar, then the IPO are obligated to notify that previous rights holder. And that previous rights holder may file an opposition to your application to stop it from proceeding to registration. But if no oppositions are filed, then usually it takes about 2.5 months to 3 months, and then you get your trademark certificate by email, and you can start to enforce it. So in terms of what your trademark portfolio may look like in the moment, firstly consider, do you have sufficient protection for your full range of trademarks? Think about whether the protection covers the full range of goods and services that your current business and future business does. Are you protected in all the territories you operate in or intend to operate in? As a UK trademark can only be enforced in the UK, but are you attracting customers from the EU or further afield? Do you need to bolster your trademark portfolio by filing for additional trademarks to fill in any gaps? Have you recently had a rebrand or changed your colours or changed your logo? And what does that mean for your portfolio? Does it mean you need to refile to cover those new colours or new logos? Or are you likely to start using different variations of your trademarks to those already protected? For example, have you added a tagline to the bottom of your logo? Consider whether you can rely on your current portfolio to enforce against third parties, or whether you need to file a new additional application. Have you got any redundant or unused trademarks in your portfolio? If you're not using them, do you need to let them lapse and save some money by not paying the renewal fees and focusing your attention to other areas in your portfolio? Also, are any of your trademarks vulnerable to being cancelled? You've got 5 years from the date of registration to put your mark to use. After that, then your trademark is vulnerable to being cancelled, and third parties may want them themselves and then use this as a tool to try and get them off you. Think about how your mark has been used since it's been registered and making sure that you're putting it to use in all the goods and services that it's been applied for. A recent case involving McDonald's and their EU trademark for the Big Mac has shown that even the big brands are susceptible to this as well, because now their Big Mac trademark is only applied to in relation to meat products and sandwiches, and no longer covers poultry products or chicken sandwiches. So there is a rule called use it or lose it. So if you don't use your mark to the goods and services that it's applied for, there's a risk of it being lost. Another consideration is whether you've got a legal representative on your portfolio at the Intellectual Property Office. Having one ensures that you don't miss any opposition notices and you won't miss any new renewal reminders. But also there was a recent change to the Intellectual Property Office that UK marks need to have a UK address for service. So it's worth checking that you are being compliant with that new rule. So I've put on the screen a couple of practical tips to protect your brand after registration. Trademark watch services will constantly carry out searches of trademark registers both in the UK and abroad, depending on the scope of the watch service, and will provide notifications if another business applies for a mark that is the same or similar to your mark. And one of the benefits of a watch service is that it notifies the business at a really early opportunity. So it allows you to file that opposition before that mark proceeds to registration. Also consider monitoring third-party activities, both online and offline. This includes conducting regular searches on Google for your brand. And if any infringing websites appear, it may be possible to raise a complaint to an internet domain host if the infringing website is based on your trademark rights, and you could even seek a transfer of the domain to into your hands. Conduct frequent Google searches to monitor adverts placed through Google. Search engines such as Google allow advertisers to place adverts that will appear on relevant search results and also on their partner websites. Trademark owners can prevent third parties from using their trademark as a keyword in relation to the goods and services that the mark is applied to, provided that the advertisement that is displayed fails to make it clear that the goods and services come from someone else other than them. And also, don't forget about offline searches as well, because that's also really important. So monitor exhibitions when you're walking around. Print media such as brochures, flyers, and newspapers are also really important to monitor other infringing use that could be going on. I've also missed up on here. Social media platforms. So you should also have a think about looking at social media platforms and where third parties can be using your brand trademark or using a very similar name. One of these platforms, Meta, which is linked to Facebook, they have dedicated IP teams that deal with infringement, and pages can be taken down within a matter of hours. And some other considerations. It's essential to collect evidence of any potential trademark infringement. This may be capturing screenshots digitally, including a timestamp of the website, copying and pasting URLs or website links, taking photographs, and retaining evidence of any customer confusion, whether in writing, on recorded phone calls, so long as you've got the consent of the person on the other end of the phone, and also making attendance notes of phone calls. Once the evidence of potential infringement is obtained, it's really important to seek legal advice to consider next steps, because if appropriate, we can contact the third party, request that they stop doing so before any serious damage is done to your brand. And if ignored, then we can consider further action, including contacting Meta with their infringement teams, contacting internet domain hosts, or even starting court proceedings to get an injunction against them. By way of an example, one of our clients is a well-established domestic services brand, and they use their network of franchisees up and down the country by capturing photographs of infringement when they're in and about in their territories. And these type of industries often rely on word of mouth and operate without any digital presence. So obtaining these photographs means that brands can act really quickly and act on them to stop any damage or being done before it is. Next, keep records. Even if you haven't got any current concerns about infringement, it's worth highlighting some practical matters which may assist in the future. It's a good idea to continually keep records of the use of your trademark against the goods and services that it's being applied to. This may include showing use of the mark by way of invoices, advertising, brochures, flyers, newspapers, and press articles. And having such evidence to hand will not only assist from an admin point of view, if any witness statements are needed, but it will ensure that evidence can be shown against any allegation of non-use of the mark. We are frequently instructed by clients, especially those in the pet services sector, to deal with competitors operating under similar names on social media platforms such as Meta and Instagram. And these infringements are frequently being dealt with by way of an initial cease and desist letter, requesting that the page is taken down and the name changed to something different. This option is inexpensive and often can get the result really quickly. But if it's ignored, then we can go to Meta, and they've got the teams in place and they take things down quickly as well. It's an inexpensive and avoids the need for the client to have any court involvement, which is going to be expensive. And if you've got any questions, I feel like I've rattled through that very quickly, but covering quite a lot. So stop sharing my screen so I can see you all now.
Can you hear me?
Hi, thanks, Alicia. That was really interesting, and sort of hopefully the room have got a number of questions. I had one question I had was in terms of cost of enforcement, and you mentioned towards the end that the cost of enforcement can be quite high. What percentage of clients would you say resolve any infringements quite easily through sort of cease and desist, and what percentage would you say then would go on to a more full-blown legal action in your experience?
That's a really good question. I would say that a cease and desist letter and possibly some further correspondence usually does the job if you are in a really good position. It gets a little bit trickier where you're relying on other rights, where it's to do with similar marks to similar services, and then you're having to rely on what's called the likelihood of confusion. But when it's very clear that someone has copied the branding, then they can be resolved very quickly. Probably about 90% of the time, because people see solicitor's letter and think, oh gosh, I really shouldn't be doing that, and stop doing it. A lot of the time, some companies are sole traders and don't fully understand what they've done is wrong, but it can escalate and be fairly expensive if the issue is a little bit more tricky in terms of the infringement that we're relying on.
Okay, and sorry, I've got a few questions, which I thought would be quite interesting to learn about. What about the owners of a brand? What happens if, so we had a client once, a couple of years ago, who had registered their trademark with their old address and then missed notices. Now, what's the situation around that then?
Yeah, it's frustrating, and it's happened to a couple of people that we've advised recently, where they've come to us and said, look, I've got a trademark for this. And then we look at the register, and it expired a year ago, and they didn't get their renewal notice. So frustratingly, that's because they've probably put a postal address down and can't always rely on the post. But if you have a legal representative, we always get emails from the IPO. So when you have let your trademark lapse, you do get a grace period of 6 months. You have to pay a fine. It's not excessive, but a bit of a slap on the wrist, but you can get your mark reactivated within 6 months. But unfortunately, after that 6-month period, you've got no other choice but to refile. And refiling means that you then may be later subject to an opposition, because someone might think that, I was here first, you've let your mark lapse, and then you could be challenged. So it's really important to ensure that you're on top of your trademark portfolio, know when your dates are, and have an address on your trademarks that is actively monitored. And that's why it's a really good idea having a law firm down, or even making sure there's an email address down, which you can easily do. You can file a form at the Intellectual Property Office, and they are really good at sending emails.
And on the issue of the being aware of the market, making sure that nobody's infringing it, can sort of businesses tap into services that provide that sort of coverage, whereby they scan the market on a regular basis, make sure there's no infringements? Is that the sort of service that a solicitor or even an agent would be able to provide?
So that's very similar to a watch service. So watch services are usually used by quite big brands. They can cover a number of countries, and you get flags, and you can have a look at what their mark is in that country. Even in the UK, you can do it as well. If someone's registered or things, sometimes you can have it where if they find stuff online, it depends on the scope of the watch service. But it's really important, if your business is possibly susceptible to having copycats, to have a watch service. But if you don't have a watch service, a lot of our clients have people within their teams that regularly go on Facebook, regularly go on Instagram, Google searches. You can even have there's quite a handy feature on Google Ads now where you can search for things. So having a look at those and seeing and reporting Google Ads is something that I'm doing more and more often now for brands, because someone has used trademark name and then vet their advert to try and hide amongst the natural search results on Google.
Okay.
So yeah, I think it's just having a monitoring service if if your business is big enough to afford it, but it's a very worthwhile cost, but also having people in your teams that regularly check.
Brilliant. Okay. Ken.
Mash?
Yes.
Yeah. I'm just interested in the effect that Brexit had. I think that there are reciprocal arrangements, but from a practical point of view, I think it's probably slightly a little more complex. But I was just wondering if it had added to the cost as well.
So when before Brexit, if you had an EU trademark, you could enforce it in the UK. Then after Brexit Day, every EU trademark was transcribed as a new mark back onto the UK register. So there's lots of marks now in the UK register where it's got an EU country as the rights holder. And because that mark was transcribed, a lot of the oppositions then go to different countries in the EU. So if you are now considering operating outside of the UK, you can use a UK trademark as a base registration for an international trademark. And it's quite a cheap, in terms of filing fees, the UK fees are fairly cheap compared to other countries such as Canada and the US, where their fees are a lot more expensive. So you can use a UK trademark to basically use that as your base registration to apply for an international trademark registration, depending on where you want to operate. So it depends on what territories, whether an international trademark is needed, because that covers quite a lot, or whether it would just be an EU trademark you need or a US trademark. It depends on what the brand is aiming to do.
Right. Just another quick one, Mash.
Yeah, sure.
In terms of registering trademarks, especially in the early days, as we tend to do with clients, sometimes, certainly from my point of view, it's not always easy to advise in terms of the number of classes that should be covered. And on the one hand, I'm aware that the cost of a class, I think, is only £50, so it's not that expensive. But on the other, if, as you've mentioned a couple of times, you register in a class and you don't use it, and then there was a subsequent challenge, would that just affect the class, or could it, presumably it couldn't have a significant impact on your ability to re-register the mark if there was just one or two classes challenged?
So that's a good question. So it can be an action to declare the whole of the trademark invalid, but it could be an application to declare certain classes, or even within the class, certain points within the specification could be challenged. So you could apply for quite a broad scope, but then you could not be applying it to, say it's like a domiciliary care provider, for example, and they've applied it to domiciliary care, but they might have in the past used the old type of classification where it includes something to do with animals. So that could likely be challenged, because a domiciliary care provider provides care to humans and not to animals. But so it can be the entire class, it can be a certain thing within the class, or it can be a challenge to the entire trademark. It depends on what the opponent is looking to do. And I've been involved in it where it's been the entire class, the whole registration, and certain bits within the registration. And that means when you are involved in an opposition, that's why you need the evidence in place to say, at the time, back in, when you first applied for your trademark, and a lot of big brands, they applied for their trademarks years ago, and you've got to find the evidence from way back when that you were applying that mark to those services back in 2000. So it's really important to ensure that you've got that evidence on file, so you can use it if anyone ever challenges it.
Yeah. The one I often think of is Tetley, because you've got Tetley beer and Tetley tea. So they are two quite opposite, aren't they? But there aren't that many examples similar. But near to us, off Richmond, there's a pub somewhere in the Dales. It's the highest. I think that's its claim to fame, but it's been going for years and years and years. And I think it was probably last year there was a challenge from Kentucky Fried Chicken because they had fried chicken on the menu, but they were able, and Kentucky Fried Chicken lost because the pub was able to show that it had been offering that on its menu pretty much going back to when it first opened. Sometimes the big boys don't always get it. They don't have everything their own way.
Yeah, that's a really interesting example. So I think it's a bit like the Big Mac example. So McDonald's, they had a fairly wide scope in their specification for their Big Mac, and I mean, everyone thinks of it as a big meaty burger, not to do with chicken, and that's why they couldn't find the evidence and they lost it. So their trademark was slightly amended to remove the chicken but keep the meat in terms of what it can be used for.
Yeah.
Chris, would you like to? You usually have a very good angle on the meeting, so I'd love to hear if you've got something to add to this.
Well, I appreciate what Alicia said. I've got we do our own kind of internal watch, as you suggested, Alicia. We get somebody to do the deep searches and to keep finding things, and surprising how often these things pop up. What's your recommended frequency for that activity?
I mean, I guess it depends on the nature of the business. If it's quite a quick paced business where things can be services businesses, maybe every month. But if it's something that it's quite a longer investment, I don't know, people buy a certain item every year. It depends on the nature of the business. But I think if you're doing it once a month, even if you just spend half an hour, 15 minutes, just Google searching and Instagram, looking through Facebook, and just seeing what's there. But also, as I said, the majority of instances of confusion we get come through franchisees seeing it out and about in the street, as well as someone said, a customer's seen this leaflet through the post, or I've seen this van driving around and they've captured the picture of the van. The van's great because it's got the phone number and it's got the email address on it, and then we can find it. So an email address is great because we know where to send the letter to. It's a little bit harder with a phone number, but there's ways around it. But I think making sure you do them regularly, depending on the type of your business, is really important, as well as utilising your franchisees, which are a great asset.
Yeah, we've had a couple of members of the public actually said, we're in Cambridge, we can't get hold of your office, and I think we don't have a branch in Cambridge. You think, but they've said, well, we've seen it on a vehicle, but they haven't got a photograph of that vehicle.
Yeah, it's really tricky, because I appreciate you're probably driving as well, and you can't just whip your phone out, but sometimes you see it on the side of the street and then you can capture the image. But so do what you can.
And again, to confirm, we have a sort of fairly standard cease and desist kind of letter that we send to people on that basis. The challenge is always, and I'm sure you've seen this time and time again, is how far do you go with those pushing somebody who is just thought it would be a good idea. They've kind of, for them, they've associated poppies with cleaning and cleaning with poppies, and they thought it would be a great idea to call poppies, or they've got a dog or a child or a house called Poppy, or they live on Poppy Lane, and they say it's perfectly legitimate. They just don't understand trademarks. They're single operators, never going to go anywhere, probably going to get a full-time job at some point in the future. and refuse to accept or just ignore or stop communicating with us. And sometimes all you have is a phone number, and you get blocked from that, and an email address, and they don't reply. So we've got a physical address, and the dilemma is just how far do we go with this? When do we call you guys and start to spend serious money, or do we just have to stop? But I think more than 50% of the cease and desist get a reply, and people genuinely try, they're upset, they don't want to have to change their business name, it's their new baby usually, and it depends on how quickly we've spotted that. But I'm interested also, if I may ask, about what you said about if you made any changes to your logo mark or anything like that. Our trademark is the name, the word poppies, and we have trademarks in several classes for that, but also that what you see is the 3 flowers, that shape. So that is also part of it, subject to the trademark, and it's certified as a kind of trademark rather than the words, isn't it? That
so it depends on if you filed the poppies on its own with the word poppies.
We haven't. It's just that it's bit above my hand, really. It's that part which is trademarked, and then the word poppies. So we feel that we're comfortable changing the brand or the font that we use, and or the words underneath.
Yeah,
we couldn't trademark cleaning service.
I think it's a good question. I think if you're happy with the keeping the poppies as is, it allows you to side by side to apply to it. But I think if you were challenging it with another brand, and they were calling them, it's a poppy, if they called themselves daisies or something, you might come under a bit of trigger, but I think you'd have to just cross that bridge and see what the actual infringing is. But it's a good idea to separate them out or do them together. Having like I said, having a portfolio of different marks as to how you use it on your letterheads, how you use it on your email signatures, uniforms, bands, making sure that you're fully protected as to how your marks are applied for. And also, when you have a trademark, you can apply for what's called a series mark. So if you have your logo stacked side by side, but you have it stacked on top of each other, it might you may be able to apply for a series mark, provided that this bit and this bit is the same as this bit and this bit. You can do a series mark, or colors as well. So if that's like red and that bit's black, or your poppies are black and the font is slightly different, it might be worth thinking about a series mark as well, just to make sure you're covered.
Okay, that's interesting. I don't think colour comes onto it. I think in the day when we registered this back in 1990 somewhere, everything was printed in black and white. The certificate is certainly black and white. There's no sense of any colour around it. We've never had any problem with poppies, Poppys, poppies, Poppies, because they do sound alike, and there's clarity of that. Even Facebook agree with that, and I don't think they're when we've complained to Facebook, or in fact using we had a copycat website appeared the other week, and we made a claim with the host under the digital rights management. Is it
the DCM, the Digital Millennium Copyright Act? It's an American
That's it, DMCA.
It's depends on where the host is based. You have to rely on US law, but that's a whole other kettle of fish. But lots of domain providers such as Nominet and other places, they have their own in-house disputes resolution teams that deal with domain name issues. And that's where we've used that for clients where the infringing website, we demonstrate that we have the rights, and they have a look at it, and then if they agree with what we're saying, and the other side don't respond, then they transfer the domain to us. So there are lots. They're all slightly different, these domain host providers. I guess it depends on a case-by-case basis as to what the infringing website is and where they're hosting it. It depends on what dispute resolution service you have to go through. So the DCMA is, it's a US based one, so it might be a little bit more complicated than Nominet, that's based in the UK. Right.
But there are processes available, and as you pointed out, we appeal to LinkedIn occasionally, because somebody's registered, showing the business name there, which is infringing our copyright and so on. But I think the biggest challenge is poppy made. or we had Poppy Dazzlers
Mm,
who are
yeah.
operating in our categories,
Mm.
but the name is sufficiently moderated or modified for it to
It's
not,
similar. It's
or
dependent.
it's
Yeah,
similar, but
if we
it's
have to
not.
run similar being applied to the same services,
Yeah,
then you have to demonstrate a likelihood of confusion amongst customers. So it then gets into a whole different complication.
that's when we need your help, and that's when
Yeah,
it
that's
starts
when
to
you
get
probably
quite
need to bring.
expensive, really.
Yeah.
Chris, I'm disappointed that we didn't hear the cat's views on trademarking issues, but he's obviously very busy. Ken, did you have another question?
Yes, it was just when Chris was talking, and I was looking at the Poppies logo, because I was going to ask how many parts made up the trademark registration. But the other question is in relation to strap lines.
Mm.
So I noticed that Chris has got cleaning services under. Would
Yeah.
you only recommend including the strap line with the application or not?
It's a good question. I guess it depends on if you're using your strap line at all times. Because if you want to enforce that trademark against third parties, you have to look at the sign overall. Now, if someone's just calling themselves Poppies, and they don't have the cleaning service, you're then relying on similar. But if the closer it is to the infringing mark, your trademark is to the infringing mark, the likelihood that the easier it is to say it's similar, if that makes sense.
Yes.
That's why it's worth having a range of how you present your marks. Having the Poppies, if you have it sometimes with Poppies on its own, if you sometimes have it with cleaning services, having a full range is the best way, because it's a belt and braces approach, depending on what that infringer might do. Because some infringers are quite cheeky and they kind of copy certain bits of it and just kind of take a little bit of inspiration from yours, but depending on how your mark is represented depends on how you can enforce it.
Yeah.
Usually it could work that you say it's a similar if they haven't got a strap line, but if it does go to looking at any sort of infringement proceeding, then the overall mark will be looked at, assessed in terms of the similarity between the two marks that are being looked at.
I think the reason I asked was just that presumably that's why you register in different classes. And would that not, if it was registered in the right class, whether you have a strap line or not, wouldn't make any difference, would it?
Yeah, so the way the classes offer the goods and services. So for example, I don't know, class 16 is paper, for example. So when you have if you have paper products that you put your mark to, like brochures, it's a good idea to applying it to class 16, as well as to the cleaning services, which is I think class 35 or 6.
I think we're in, but
so again,
yeah, I think it's 37.
I can't remember. I have to double check, but I think then so it's
we're 35, the franchise company.
Franchising is 35, and that's like business and
Yeah.
marketing. But it depends on, it's also where where you're applying the mark and services to. If you have, if you have printed material, or if you do like, educational seminars to your franchisees as well, it might be worth considering filing it in class 41 for educational services. It also really depends, because having too many classes and not using them goes back to the point that you could be vulnerable to having that mark challenged in that class. But making sure that your core goods and services are on the application, on the registration, is really important, because and also what the actual specification is on the trademark, because having something too broad is also, it cuts both ways really, because if you're applying something to, I don't know, recruitment services, but actually you do recruitment services for, I don't know, the NHS or something, then someone that comes along and you've just got recruitment services, but you don't have it in relation to, recruitment services for the NHS, it's a bit more of a tricky argument you have to make. It's not impossible, but it depends on, it's really important to make sure that your specification for the classes is actually what you do, but also what you intend to do in the future. Because when you apply for the trademark, so long as you've got a bona fide intention of applying the mark to those goods and services in the future, you can be ambitious and say, in 5 years' time, 10 years' time, because the trademark lasts 10 years, you can say, I really want to move into, I don't know, cleaning commercial property or something like that. If you just do residential property cleaning, you can be ambitious and say, I would like to see that in the future. And so long as you are being genuine in that, when you make the application and make the declaration, you can do that.
Trina, I was wondering, did you have anything that you wanted to ask? Hi.
I'm fine. Yeah, no, I'm good.
Are you good? Fantastic. Okay, then. Just I just want one or two questions, Alicia, if it's okay. The first question, I suppose, is the obvious question, which is, if I'm a business, when should I start? I mean, if I'm a new startup, for example, when should I start looking at the issue of trademarking? Is it something I need to? I've got no trading history.
Beginning. Yeah, because it's some people come to me and they say, I've got my heart set on this name. You know, I really love this name. We do some clearance searches, and someone up, you know, somewhere completely where you've never been before has a trademark registered, and then they're like, oh, I'm really upset. They're really upset because they can't use that name. But if you think about the grand scheme of things, if you go down the line of applying, you've lost your and it's challenged. You've lost the filing fees. You've lost all that branding money you've spent having your marketing team and graphics team do the logo, making it look nice. It's really important to have a think about clearance searches early on before you spend a lot of time and money with that name and developing logos and
what about the issue of will a company need some trading history to make that application, or is that irrelevant?
So when you apply for a trademark, you have 5 years from the date of it being entered, it being filed, sorry, to put the mark to use. Okay. No one can challenge in the first 5 years that you've not used the trademark to the goods and services. Right. There is a box on the form, and you bypass that box, because you don't, the IPO allows you that 5-year grace period to put the mark to use. So it's really important to, you know, do the checks, but also once you've got that mark registered, you have that 5 years to use it, and it's important to use it.
Okay, fantastic. And the final question from me is the issue of the social sector, charities and those sort of organizations. How are they affected in any special way in terms of trademarking? Because we've talked a lot about business trademarking, we talked about properties, whatever, or is it more or less the same regs and rules and regulations all apply to the social sector and charity sector, not-for-profit sector, as they do for businesses?
Yeah, so charities can still apply for trademark and can still be intellectual property office holders. So I think it's just what they would do is they might have a different approach to enforcing it, but their trademarks might likely be very specific. So it would be very, and also it might be worth, if they've got, as I mentioned, a geographical name within their, so if it was, for example, say Brixton's children's charity or something, they might likely be unlikely to have that as a word trademark, and they might have to consider a more graphical logo that's very distinctive in applying for the trademark. So yes, they can hold trademarks, but there might just be different kind of approaches they take to enforcing it to minimize PR, but also what the charity name is, because a lot of charities, or smaller charities, might have links to where they're based.
I understand. Brilliant. Okay. Well, you know, back to the floor. If anybody else has any further questions? Just
a quick point, Mash, for
yeah, sure.
Alicia Services, because as consultants we get involved, as you know, at the very beginning, and certainly we've found that using professional services is really beneficial. And although not many trademarks get challenged, the difficulty always arises when they do. And we've found it, you know, really helpful for our clients to be able to use services such as yours, because when we've not lost that many, and generally because of the experience, you can guide us and our clients in terms of how best to defend the challenge, and generally I would say 9 times out of 10 we've been successful in, you know, in terms of we may have had to have the odd modification, but generally it's gone through and everybody's happy. So definitely beneficial using services such as yours.
Okay, well, Alicia, thank you for the fantastic sort of presentation and the information you provided, because there's loads of stuff there that, you know, I sort of never heard of, and you know, and I've been a consultant for over 20 years, and I'm sure we all learned something. And thanks to Amy for the fantastic technical support. She did a brilliant job there, and for managing and hosting the event. At our next event, we are going to be hosting Pip Wilkins from the BFA, and she'll be talking about the 2024 BFA franchising survey. And you know, that was launched last week, and a lot of us that were on this meeting were there, and I think that'll be a really interesting sort of conversation. But for now, thank you everybody, and if anybody has any questions or anything like that, just feel free to email myself or Ken, and have a great weekend.